First of all, I would like to say that it's an honor for us to have you here as a distinguished lecturer, and thank you very much for this interview. So, may I first ask you to provide us with a brief information about the concept of jurisprudence or philosophy of law and its role in the legal education in universities, and how does philosophical thinking contribute to the education of law? To put it in negative terms, can't law be taught in universities without referring to the philosophical thought?
Yes, I mean, law can be taught without doing any philosophy of law at all, and you can learn how to be a perfectly competent professional lawyer without ever thinking about these philosophical questions. But I think if you're taught law that way, you're really just a kind of conveyor belt for assumptions that have been inherited uncritically. And I think that lawyers who've learnt law in that way are often incapable of dealing with the sort of fresh problems that in periods of critical change legal systems tend to be confronted with. So particularly at present, I think with the world being confronted with a multitude of new legal political problems that we've never had to address before, I think it will be a very sad thing if we can't have a legal profession that really has the appropriate intellectual background for addressing some of those questions. And I think if it hasn't got any background at all in philosophy of law, then it won't really be competent.
Okay, thank you. And actually my second question is very related to the first one, and it's regarding the legal practitioners. I'd like to pose it in any ways, but if you don't have anything to add, like some lawyers claim that legal philosophy is not indispensable for resolving the practical problems of a legal nature. So what do you think of this proposition? Do you think it is indispensable for each legal scholar to have a knowledge of legal philosophy, regardless of the area of law she or he is specialized in? So anything you want to add, or the first answer is also relevant? So
okay, well, it depends really what exactly they're doing and the sorts of problems they're dealing with. I'm sure that some legal problems are simply technical problems about working out the relationship in between various statutory provisions. And they can be resolved in a way that does not require you to decide in between various sets of background assumptions about law that might otherwise inform legal thinking. But whilst some legal problems can be resolved in that sort of way, there are also always going to be legal problems that can't be resolved that way, that raise much broader questions about the relationship between legality and say justice, or about what exactly we mean by legality, what exactly is a judge's duty, for example. The answers to these questions are by no means clear. And so surely these are questions that we would expect members of the legal profession to be able to address intelligently and thoughtfully, and they're far more likely, I would hope, to address those issues intelligently and thoughtfully if they have some background in philosophy of law.
Okay, thank you. And actually, my other question also related directly to your answer now. So how should legal scholars demonstrate the relationship between law and concepts such as legality, liberty, independence, and justice while teaching in universities? That's my other question.
Well, they need to have a sound understanding of the relationship in between these different ideas like legality, justice, liberty, and so on. And of course, for me, a sound understanding means an understanding reflecting my opinion on these matters. However, I think the important thing is that they should be aware of the range of opinion that has evolved through the philosophical debate. They should be aware of the way in which philosophers have approached these questions. They should be aware that they are indeed profound philosophical questions that in their way go right back to the origins of Western civilization. We'll find these issues being discussed in ancient Greece, and they have a continuous history right up to the present day. It seems to me an outrage if those people who are charged by society to address these problems, namely judges and lawyers, really know nothing whatever about that intellectual tradition of which they are the heirs, because if they know nothing about it, they can't pass the heritage on to a future generation, and in that way we'll all be profoundly impoverished.
What should be done within the context of legal education in order to prevent that prospective judges render arbitrary decisions in the future?
I think that there needs to be, within law teaching, a much more rigorous emphasis upon the effort to try and articulate a systematic body of doctrinal principles, rather than having a form of law teaching and legal writing that simply aims at expounding fairly low-level detailed rules, making rather journalistic commentary on recent cases and so on. Academic lawyers must be asking questions about what the underpinning principles are and what the fundamental values being served are. Otherwise, law books really become just like telephone directories, just a convenient way of gaining access to some technical information. A law book should be much more than a telephone directory. And I think this applies in every area of law. I mean, if you're writing about planning law, let's say, you should be thinking about what are the fundamental values served by planning law, and what sort of fundamental principles should be thought of as structuring and informing planning law. And your exposition of the technical detail should always be informed by and should also inform your views about those matters. So I would hope for a much better and a more sophisticated form of legal writing, and in association with that, a much better and a more sophisticated form of law teaching, which I think is far too often, at least in Britain, I couldn't possibly comment on Turkey, is far too often concentrated on merely giving the students technical information.
Yeah, we have sort of the same problem here. So how do you pursue the education of jurisprudence at Cambridge University Faculty of Law, and do you have any recommendations to us with that regard?
Oh yes, well I have a recommendation for Cambridge University, in fact, which is that Cambridge University should make jurisprudence a compulsory part of its law course, because at present it's merely an option which the great majority of Cambridge law students choose not to study. And I think that no one should receive a law degree from a great and famous university who has not studied jurisprudence. And I would make exactly the same recommendation to all Turkish law faculties, that this should be thought of as an essential foundation for legal study and an essential prerequisite for a law degree.
Okay. Thank you. And how do you evaluate the effects of the jurisprudence courses you lecture at Cambridge University? Like, is there a method you pursue to assess the influence of the education of legal theory?
I think the approach of all of us who teach legal philosophy at Cambridge is quite simply to choose some very good and fairly contemporary books, I mean late 20th and early 21st century books, and to simply read those books, help the students to study them and think about them and address the issues that are investigated by those books. So I'm thinking about things like Hart, Dworkin, Rawls, Lon Fuller. I think it's by studying these great modern classics of the subject that you really acquire a deep understanding. So it's a very simple approach.
Another question not related directly with the law, legal education. So where do you see the place of politics in legal education? Oh, first now legal education. And do you think legal education should be refined from any political approaches?
Right. Well, the word political is always a rather hazardous one, because in popular speech it's often equated with party politics. And clearly we need to avoid using the teaching of law or the teaching of legal philosophy as some sort of instrument of party politics. I think we should be trying to address issues which are more fundamental. But in a broader sense, I would say that philosophy of law is really just a branch of political philosophy, and that in understanding philosophy of law, we're really trying to understand some of our central political values: justice, legality, equality, human rights, freedom. We're trying to understand those values and how they interrelate. When we come to understand those values properly, I think that we will come to see that legality, itself an enormously important value, indeed I might even say the central value of liberal democracy, requires that the law should be an orderly body of principles which have some degree of independence, at least, from the variable moral viewpoints that one might otherwise hold and that the citizens within a liberal democracy might hold. So I think in coming to understand these fundamental political values properly, we come to see how important it is that law should have a kind of autonomy and integrity of its own, and that legal studies should have a firmness of structure and a discipline that it will not possess if we continue to teach it in the rather unsystematic, purely technical way that I mentioned earlier.
And what is the relationship between the idea of law and democracy? Like, where do you see the place of democracy within this idea?
Okay, well, I take the view that the idea of law is in part the idea of a set of conditions within which we can have a degree of freedom as independence from the power of another that we could not otherwise possess whilst living within a human community. So the idea of law is the idea of that highly distinctive value. Now, the protection of that same value can be deepened and extended by democracy. So democracy is like an extension, a deepening of the same value that is protected by the rule of law. And I infer from that that if you believe in the rule of law, then you may also have good reason for being a democrat. But at the same time, I think it shows us that democracy without the rule of law is not really a value at all. It's merely mob rule. So democracy cannot compete with the rule of law. These are not two values that can clash and compete, because the minute that the value of democracy starts to clash with our idea of the rule of law, it forfeits any value it might otherwise have. So the rule of law is always the priority here.
Okay. So So now I would like to refer a little bit to your book, Law as a Moral Idea. Here you refer to the concept of law as an intellectual archetype to which actual instances of law merely approximate to various degrees. And how could this archetype, do you think, become closer to, and are you optimistic with regard to the realization of this archetype someday in the future? And what would you advise to legal practitioners and scholars to pursue such approximation?
Okay. Well, I'm not a natural optimist. However, I think that within my lifetime, the sophistication of the approach to law and legal studies within the student body, or the student body that I encounter in Cambridge and elsewhere around the world, has improved and increased. And I think that people are now being encouraged to think about questions that I wasn't exposed to at all as a student. And this is a good sign, because the more we think about these issues and the more we talk about these issues, the more we improve our understanding, and some tiny part of human injustice and oppression stems from intellectual confusion, which could perhaps be removed through dialogue. So in that respect, I'm optimistic. But more broadly, I'm rather pessimistic. There are many, many pressures upon the rule of law, and many pressures upon the intellectual standards obtaining within universities and within academic discourse. So I don't think there's any historical inevitability about a steady march in the direction of justice, virtue, the rule of law, or anything else. Everything hinges on historical contingencies, and it's really the upcoming generation who will have the responsibility for ensuring that we are on the right road rather than its opposite.
Okay, thank you. And again, in your book, you relate the nature of law with the notion of freedom as independence from the power of others, as you just said. And how independent, and in your own words, how protected from the interference of others do you think citizens are in today's societies?
Well, of course, it's a very difficult question to generalize about. But of course, modern states confer upon officials enormously extensive discretionary powers. And whilst most states have developed bodies of administrative law aimed at constraining and regulating in various ways those official discretionary powers, the body of administrative law itself strikes me as really quite unclear, although I'm not an expert on it, and that's a huge understatement. So clearly there is an enormous problem here as the regulatory welfare state has become more and more powerful. We've also got further and further away from the rule of law. And there may even be a fundamental conflict in between the idea of the regulatory welfare state, a state which is intruding into private life on many, many fronts and conferring great discretionary powers on state officials on the one hand and the rule of law on the other. So there may be a very, very fundamental problem there. I tend to think that one of the ways in which we have to address that problem is through looking for market-based, property-based solutions rather than central government regulatory solutions. But I mean, that is no more than a very vague agenda and a question mark over a huge problem. But I think that probably has to be the route we go down if we wish to really fully realise the idea of governance by law as opposed to governance by official discretion.
Okay. And what weight do you think should be given to cultural relativism in the incorporation of international rules into domestic law or in legislation in general? And what if the legislature, for instance, resorts to the idiosyncratic moral values of that particular state to justify the exclusion of some international human rights rules from domestic law?
Right, okay. Well, the idea of cultural relativism or of moral relativism, it can mean a lot of different things. If it's simply an observation that different kinds of communities may endorse different moral precepts, I find it uncontentious. But we can still ask whether those moral precepts are sound, whether they're good moral precepts. When we ask that question, we're really asking a question about how those moral precepts serve human flourishing in that community. And I take the view that we do not, in fact, have infinitely diverse conceptions of human flourishing, that there is such a thing as our common humanity, which really is a shared understanding of broadly what counts as a flourishing, worthwhile human life. The idea of a flourishing, worthwhile human life leaves ample scope for diversity, but there are limits to that possible diversity. And it seems to me perfectly clear that, for example, if a community chooses to leave women without any education at all, when it could provide them with an education, it is not catering for the flourishing of all of its citizens. That strikes me as perfectly clear. So when we talk about cultural diversity and human rights, we're very often, I think, talking about that kind of situation. We're talking about communities doing things which quite clearly do not serve the flourishing or the well-being of their citizens, and therefore I think that activities of that kind should not be justified by an appeal to cultural relativism, because although there is such a thing as cultural relativism, it simply does not obtain at such an extremely fundamental level. At that level, we have a common humanity, we have shared ideas about human flourishing, and as an expression of that, we have ideas of human rights, which are, of course, for that very reason, growing ever more influential.
And lastly, like having mentioned the situation about human rights, I would like to proceed with a question related to two debates still relevant throughout the world and also very popular in Turkey at the moment. What do you think about the two concepts, capital punishment and abortion?
Okay. Well, capital punishment, I can't see much of a case in favour of capital punishment. Whether we approach it through a retributivist way of thinking, or we think of it just in terms of more utilitarian, aggregative goals, I don't really see there's much of a compelling case for it. I endorse many of the quite conventional views about it, that it can have the effect of glamorizing the crimes involved and all sorts of other adverse consequences. So capital punishment, I've got a clear opinion on. Abortion, well, I do feel somewhat more divided here, but if you're asking me to just articulate my broad overall sympathies, I I do tend to really favour the woman's right to control the integrity and autonomy of her own body. So, I mean, I do tend to have much more sympathy for what very crudely we call the pro-choice camp rather than the pro-life camp. Although I do fully accept that it is a difficult issue. But I think it would take a lot before I would be persuaded that there was any convincing case for making our laws on abortion more restrictive of a woman's right to choose than they currently are.
Thank you so much, Professor. This was all, and thank you very much for your answers.
Okay, thank you.
Thank you.